for the school. After all, how is it fair that the school be forced to pay if private corporations can be exempt? Now the Supreme Court revived the university's religious objections to the requirement for contraceptive coverage under the Obamacare law, throwing out the lower court's decision that was in favor of the federal government. The justices asked the 7th U.S. Circuit Court of Appeals to reconsider its decision against the South Bend, Indiana-based Roman Catholic University in light of the June 2014 Supreme Court ruling that allowed certain privately owned corporations to seek exemptions from the provision. This case is part of the national litigation concerning religious objections to the contraception provisions of the 2010 Not So Affordable Health Care Act, also known as Obamacare. Now, the law requires employers to provide health insurance policies that cover preventative services for women, including access to contraception and sterilization. Now, as I'm sure most of you know, in the Roman Catholic tenets, those are both major, big-time no-nos. Now, this would have major ramifications across the country. It would be a major blow against Obamacare as a whole, and also would, at least hopefully, move to silence some of the deadheads, folks like Miss Sandra Fluck, who, as you can famously recall, made an effort to sue Georgetown University, also a Catholic university, because for whatever reason, she just couldn't afford her own contraception. And evidently she just couldn't contain herself either and had to be participating in sexual activity. Don't know exactly when she was finding time to study. I think we all know how that played out. It was all attention. It was all to set herself up as some new darling of the Democratic Party to try and run for office, which she did run. Didn't work out for her, but she hasn't went away just yet. This could make her go away, or make her at least have to come up with a new stick, something new to get on about. At any rate, that's noteworthy, and I keep asking the question as well, if they're going to vacate the ruling, why didn't they just go ahead and reverse it? I mean, they have that authority, and I understand it's probably a case of standard procedure, letting the court have an opportunity to get itself right. And that might be the case. I don't know. But what really concerns me more than anything else is that in this age, with so many courts across the country constantly saying that they're overwhelmed and overworked, why not just take a little bit of that load off instead of making them have to hear the case again and making the University of Notre Dame have to send their lawyers in and run up the cost for everybody as well? Wouldn't it have just been easier? Shouldn't we expect common sense to return at least to a place like the Supreme Court? Just thinking out loud. Also, as I'm sure a lot of you heard, back on March the 4th, the Supreme Court heard oral arguments in the case of King versus Burwell. Now, that is the Obamacare challenge that involves the insurance exchanges created by Obamacare and the IRS's interpretation of the provision of the law that authorizes tax credits for health insurance purchases through an exchange, quote, established by the states. Now, there were 36 states that chose not to establish their own exchanges, so the federal government stepped in and created federally run exchanges in those states, aka the marketplace. The IRS then extended the tax credits for insurance purchase through the federally run marketplace. That's where things get tricky. That's an interpretation that certainly seems to be in direct violation of the uncommonly plain language of the law. Again, the law said specifically, quote, exchanges established by the states. In other words, nowhere in Obamacare, the not so affordable health care act, is there any place that establishes federal authority to create a federal marketplace. Nor is there any place that allocates that funds should be made available for people purchasing through there. The language seems unusually clear. Now, the Supreme Court has to decide whether the IRS interpretation will stand or if the tax credit should have never been, and therefore by default can no longer continue, to have been granted in the first place. That should have never been granted to the folks in the states that don't have exchanges of their own. That is what the law seems to say. That's what the court's going to have to decide. Now, either way, we're going to have to wait until sometime around June before we'll know what the court decides. That's when they'll release the ruling. Questions arise. What happens if the Supreme Court invalidates the IRS's interpretation? Will this be the first domino to fall in a series of events that brings Obamacare to a crashing end? Or will it simply result in millions of Americans losing their tax credits, but still being expected to keep their coverage? Will this result in Americans having to pay back the tax credits already sent to the insurance companies? How should Congress and the states respond? Now, several lawmakers have already promised quick action on fixes if it becomes needed. But can we really count on swift action from Congress, especially with so many in Congress opposed to Obamacare in its total? I'd go so far as to even suggest that they shouldn't, based solely on the fact that the law should have never been implemented in the first place. But at this point, I have to say that I do have a great deal of concern for the folks who have been receiving the tax credits, especially the ones who were forced to take the tax credits, forced by the law in order to pay for policies. And now, these same people may very well be on the hook to pay those credits back to the IRS because they won't be able to continue to purchase their insurance. But whether they can keep their policies or not, they still would be expected to pay back the IRS. Now, if any of you have any doubt as to whether or not that might happen, just ask anybody who had a marketplace policy last year, but had their policy canceled before the year was over. Those folks got stuck paying both the penalty for not being covered and paying back the tax credits. Some folks were hurt very badly. There's two people I know personally that we had conversations with at depth. Both of these people went from expecting refunds in excess of $1,000 to actually owing more than $1,000. This happened because they were treated. Now, it was prorated on their penalty. So they got credit for being covered for the amount of time they actually had coverage. But they still had to pay a penalty based on the amount of time they did not have coverage, and they had to pay back the tax credit that they received to assist in paying for their coverage while they had the policies. And in both cases, this was an instance where paydays fell funny, and they were a day or 2 days late in sending in the payment. The insurance companies canceled their policies immediately and made them jump through so many hoops to try and reinstate a policy that they weren't able to do it. This is what happens when the law says you have to have something. The companies involved with providing you that service don't get in a big hurry to help you out. So it's very real. Now, another big question at that point becomes, should the states that don't have exchanges give in and build their own exchanges at that point to protect their people? Well, the fact that the administration has said very loudly that they have no plan B if the court rules against the credits, well, that tells me one of two things. Either A, they're trying to influence the court not to rule against them, or B, they're looking to put all the pressure on the states for the fix to try and force them to build their own exchange. Now again, I don't like the unconstitutional power grab that is Obamacare. But I don't want to see any state be forced into participating in this unconstitutional act. Add the fact that even if these states started an exchange tomorrow, it wouldn't protect anybody from having to repay credits already issued either. Now, any action that Congress would take to, quote, fix things could be made retroactive. And that would protect the people, but anything less leaves a lot of Americans in a tough financial spot. Not to mention the fact that it still leaves our government in clear violation of the Constitution. Alright, I'm going to take a quick break at this point, and then we're going to change gears a little bit. I want to talk about the bullet ban that went bust, which we also talked about this past Sunday, but I know a lot of the folks listening here don't catch the show over there, so let me take this break and then we'll be right back. Stay with me.
I'm looking for a miracle. Looking for a miracle. Angel looking over me. Just a breath of hope to see. I'm looking for a miracle. Looking for a miracle.
All right, ladies and gentlemen, we are back, and yes, indeed, we are looking for a miracle. We're looking for the miracle of the return of respect to America. We're looking for the miracle of us being able to put aside those things that we've allowed other people to use to divide us and to pull ourselves back together as a nation of laws and of people who understand the Constitution was built by the framers. The framers built it in a fashion that was designed to bring forth liberty and justice for everyone, and that none of that means that you're owed anything. It just means you've got the same shot as anybody else to go out and try to make it. That's what it means. That's the miracle we're looking for. And it is a miracle, if we can find it. I wanted to talk a little bit about this so-called M855 green tip ammo debacle. Now, the Bureau of Alcohol, Tobacco, Firearms, and Explosives is evidently no longer moving forward with the proposed ban of one of the more popular, currently, types of bullets that are used in AR-15s. Facing strong opposition from gun rights advocates and a large number of members of Congress, the agency said in a statement this past Tuesday, a week ago from today, as it turns out, that it would not seek to issue final guidelines, quote, at this time. The ATF said that it would instead wait until Americans have finished commenting on the federal regulations and evaluate those comments and suggestions before, quote, proceeding with any framework. Now, of course, the statement followed 52 senators and 238 House members joining in opposition to any attempt by the Obama administration to ban the ammo. The agency also said the decision was based on the overwhelming interest in the issue and the issues raised in the comments received. In their statement, the